Good morning, and welcome to the Supreme Court of the United Kingdom. This is the hearing of an appeal concerning the jurisdiction of the Courts of England and Wales in relation to claims for damages arising out of allegations of environmental pollution in Nigeria. The appeal is brought by His Royal Highness Emery Godwin Beke Okpabi and others, and the respondents are Royal Dutch Shell Plc and a subsidiary of that company, Shell Petroleum Development Company of Nigeria Limited. Today, the appellants are represented by Richard Hermer QC, supported by Robert Weir QC and Edward Craven. The respondents are represented by Lord Goldsmith QC, supported by Sophie Lamb QC, Dr. Conway Blake, and Tom Cornell. I will introduce each of the justices before inviting counsel to begin his submissions. I am Lord Hodge. Lady Black?
Good morning.
Lord Briggs?
Good morning.
Lord Kitchen?
Good morning.
Lord Hamlin?
Good morning.
I now invite you, Mr. Hermer, to make your submissions.
Divide my submissions, if I may, into 5 sections. Firstly, a short introduction and overview. Secondly, Vedanta and the applicable legal framework. Thirdly, how the appellants put their case on duty of care. Fourthly, the substantive and procedural errors in the approach of the Court of Appeal. And fifthly and finally, a short summation as to why this court should conclude that there is an arguable duty of care against RDS. In light of time, I hope it's acceptable if on occasion I simply give you reference to documents rather than taking you to them all, and I hope the court received a short summary of the documents, a list of the documents that I'm going to refer to that I hope is going to help this morning.
So, yes, it arrived this morning, thank you.
Thank you, my lord. Can I then start with my overview? The case is simple. We submit that the appeal can be resolved by reference to little more than a copy of the judgment of this court in Vedanta and a copy of the pleadings. The majority of the Court of Appeal fell into error by adopting a far too restrictive test for the identification of the duty of care, and they compounded that error by applying an approach to the assessment of evidence that was contrary to authority and unfair, not least their refusal to countenance the relevance of future disclosure to the particular factual dispute they were presented with. Simply put, had the Court of Appeal had the benefit of this court's judgment in Vedanta, and had they applied that rubric to the materials before them, then they could only have come to the conclusion that the claim was, at the very least, arguable. And indeed, as we set out between paragraphs 12 and 13 of our printed case, we had understood this court, when granting permission, to have considered that the judgment in Vedanta provided a sufficiently clear framework to dispense with the need for a hearing. And that was not, as the respondents suggested, because Vedanta somehow doomed the appellant's case. That being so, then the same appeal panel would surely have done precisely what it did the very next day in the Unilever case and deny permission on the basis that there were no grounds for interfering with the factual conclusions below. For your note, contrast the order granting permission here at EF 671 with that communicated the following day at EF 5912. But in any event, as we have noted in our printed case, we're not alone in thinking that the decision of the majority is incompatible with this court's judgment in Vedanta. It's a view shared by the interveners, by the editors of Clark and Lindsell, and by the unusually large number of Rule 15 letters submitted both pre and post Vedanta, including at EF 3512, submissions from a group of distinguished academics from universities across the world. Furthermore, the New Zealand Court of Appeal, in adopting an approach to liability almost identical to that in Vedanta, expressly rejected what they considered to be the too narrow approach of the majority in Okpabi namely that the existence of mandatory group-wide policies cannot be enough, could never be enough to establish liability. And we say Vedanta has provided much welcome clarity. Leaving the decision of the majority in this case in place would, we respectfully submit, be a retrograde step, because it would introduce not simply uncertainty as to the scope of the law, but would have at least two other undesirable consequences. Firstly, it would give rise to great uncertainty as to what is required by a party to be proved at a summary judgment or equivalent service out stage. That is because, we submit, any objective reader of the judgment below will immediately appreciate that the materials deployed by the claimants in Shell were far more extensive than those available in Vedanta, as we've highlighted in the short annex to our printed case at EF 283. And if the evidence in Shell is not enough to establish an arguable case, then judges and litigants would be entitled to ask whatever would be. It would encourage precisely the sort of evidential arms race that has been deprecated in this case and others, leading without doubt to the form of expensive, time-consuming interlocutory battles that Lord Newberger noted in VTB permit a wealthy party to wear down a poorer party, or a party with a weak case to prevent a party with a strong case from enforcing its rights. Secondly, upholding the judgment below would run the risk of seeming very unfair indeed. Now, in one sense, that might sound more like a jury submission, the one fit for the Supreme Court, but it is, we respectfully submit, legitimate to underline what may be obvious. The summary judgment process is designed to weed out cases that are on their face legally or factually hopeless, in which, as Lord Hope put it in Three Rivers, where it is clear beyond argument that a case is contradicted by all the documents or other materials on which it is based, and is simply not fit for trial at all. The threshold is, we respectfully submit, deliberately low, because otherwise dismissing cases without access to a trial process would defeat the very purpose of our civil justice system and infringe a fundamental right to a fair trial. Now, these cases concern not simply a matter of profound importance for the claimants, but a huge public interest. Whether Royal Dutch Shell is responsible for the devastation of the Niger Delta has been one of the most prominent global environmental controversies for decades. And this case goes to the very heart of that issue, and it is plainly not being brought on a speculative or flimsy basis. It relies not only on the evidence of senior insiders that RDS regularly intervened in relevant aspects of SPDC's operations, but relies on RDS's own published materials, proclaiming to investors, shareholders, consumers, and the public at large that it acts to prevent or minimize precisely the type of damage sustained by the claimants. And we respectfully submit that the claimants have a right to a trial to have that case detested and determined on the full array of relevant evidence. And to deny them that right would risk undermining, in all those circumstances, faith in the good administration of justice. My lord, my lady, that's what I intended to say by way of opening and summation. Could I turn then to Vedanta, which we've addressed between paragraphs 116 and 129 of our printed case. And obviously, mindful of the composition of this court, I'm going to apply more than a modicum of deference and speed. Could I just highlight 5 aspects of the principles that govern the identification of an arguable duty that we derive from Vedanta? So first, and perhaps the most important, is that made by my Lord Briggs at paragraph 49, EF 4083, which is that in assessing the liability of a parent company to those injured by the operation of a subsidiary, a court applies the normal rules of tort law governing liabilities for the acts and omissions of third parties. There is nothing special or conclusive about the parent-subsidiary relationship that gives rise to a discrete rule or category or evidential presumption. Second point is the identification of whether liability arises under that legal rubric is a factual inquiry. As my lord put it towards the end of paragraph 49, everything depends on the extent to which and the way in which the parent availed itself of the opportunity to take over, intervene in, control, supervise, or advise the management of the relevant operations. And that's a factual inquiry. Point 3, that factual inquiry should be conducted without preconditioned assumptions as to how it might apply to a large multinational corporation. Not least because, as my lord identified at paragraph 51, there are a myriad of different ways that international groups of companies might choose to structure themselves. There is no limit to the models of management and control that they might choose to put in place. Point 4, there is no limiting principle that dictates that liability cannot arise by virtue of a fact that a parent laid down group-wide policies and guidelines for its subsidiaries to follow. Each case, no doubt, will turn on its own facts. But as my lord explained between paragraphs 52 and 3, such policies could give rise to liability in a number of scenarios, or as we've described them in our printed case, routes. Now, to be clear, our identification of routes is nothing more than what we hope is a convenient taxonomy for demonstrating how the Court of Appeal adopted an overly restrictive approach. They are not advanced as anything other than non-exhaustive illustrations of the types of facts that may give rise to a duty. And indeed, in this case, the existence of relevant policies, as I hope we've made plain in our printed case, is only one of a number of sources of evidence on which we rely to establish an arguable duty. Fifth point, in cases in which there is a real dispute between the parties as to the nature and extent by which the parent controlled or intervened or supervised, etc., in the relevant operations of the subsidiary, then those factual questions can only fairly be determined through the disclosure of documents in the possession of the defendants, but currently unavailable to the claimants, a point that my lord made at paragraph 45 of the judgment. Now, those are 5 points of principle that we rely on from the judgment, but it's also instructive, we say, to examine how they were applied in Vedanta. At paragraph 55 of the judgment, my lord sets out the materials on which the claimants relied. They were the pleadings, which set out over 13 pages a section on duty of care, including lengthy excerpts from Vedanta's published materials. There was also a service agreement between the parent and subsidiary, and a statement from a middle manager in the subsidiary company. But at paragraph 61, my Lord Briggs concludes that even putting aside the agreement and the statement of the witness and simply having regard to the published materials referred to in the pleadings, it was well arguable that a sufficient level of intervention might be demonstrated at trial after disclosure of relevant documents. Now, as in Vedanta, we rely on the existence of the policies that RDS proclaim exist and apply to SPDC, and we also rely on the fact that they appear to be mandatory, detailed, and go precisely to the issues that have led the damage complained of. But as I've said, our case on material intervention extends beyond reliance on mere mandatory policies themselves. As I'm going to show you briefly, we rely upon evidence, for example, of centralized expertise provided by the parent and top-down intervention in highly relevant areas to the damage sustained. My lords, my lady, that's part 2 of my submissions. With your permission, I'm going to turn to part 3, which is the claimant's case on the evidence. And with my lord's permission, I'm going to spend a little time on this because it provides not only the context for demonstrating the materiality of what we say were the errors of law below, but also the foundation for how we say this court can be readily satisfied that the case on duty is well arguable. Because however much the respondents may repeat the mantra that this is an impermissible challenge to the factual findings below, this appeal does not require the court to unpick detailed evidential evaluations. Rather, the task is one that can be described in three short, trite steps. Firstly, an analysis of whether the court below did apply the wrong legal test. Secondly, whether any such errors were material so as to vitiate their conclusions. And thirdly, if satisfied that they are you nevertheless satisfied that the claimant's case is at least arguable? Now, none of those steps require the court to engage in a lengthy trawl through all the evidence. In addition to some short observations about our witness evidence, I'm only going to take you to 4 documents, all at some speed, and they are the pleadings, one RDS sustainability report, which is the source of some of the pleadings, but not some of the excerpts in the pleadings, but not all. And then 2 documents we did not have at first instance. The first is the RDS framework. The second has a slightly longer title. It's the HSSE and SP framework. It stands for Health, Security, Safety, the Environment and Social Performance. I'm just going to refer to it as HSSE framework. And I can take them all at some speed, not least because some of the relevant parts are set out in the judgments of Lord Justice Simon and Lord Justice Sales. So if I may start with the pleadings, and before actually taking you to them, just make a few observations. As you'll see, the claimants' both pleadings in both cases are detailed, but it's right to note that since they were served, there have been further developments in our evidential analysis as to why a duty of care is owed. In particular, our understanding has been deepened by access to the former employees in the Shell Group who've given their statements, and also sight of the 2 important new documents, the framework documents. There have also been obvious legal developments since we pleaded the case almost 5 years ago. And you may note in the pleadings in this case a great deal of stylistic overlap with the Vedanta pleadings. In particular, they set out a case on parent company liability, in part by reference to what we describe as the Chandler indicia. But as my Lord Briggs noted at both paragraph 56 and 60 of Vedanta, in fact, applying the Chandler indicia imposes a higher threshold for the claimants to satisfy than the one they are in fact required to meet. Now we have elected not to keep producing draft iterations of the pleadings on a rolling basis as the law and facts have developed, but rather to advance our application on the original pleadings, which no doubt will require refinement in due course. But to be clear, as we set out between paragraphs 51 and 63 of our printed case, our submissions are that the pleadings articulate a well-arguable case on duty and breach, and that the new evidence and legal developments are not only consistent with it, they reinforce it. The court will note from both sets of pleadings that these are cases premised on multiple spills over a number of years, causing extensive and devastating damage to the land, waterways and livelihoods of the local communities. Both claims are about systemic failures to either stop devastating oil spills or remedy their catastrophic impact. Neither Bille nor Ogale could possibly be described as to claims arising out of a single event or the negligence of a careless employee dropping a hammer on a pipeline. In Bille, for example, my lords, my lady, by reference to satellite imagery, the pleadings assert that 13,000 hectares of mangroves have been damaged by spills from pipelines. To give you a sense of that, that is well over twice the size of Manhattan Island. It's about 20% more than the size of Liverpool, our 4th largest city by area. And mangroves, which abut the lands upon which the appellants live, are critical habitats for them. They are the source of fish and shellfish, which sustain the economy and our food sources. Could I just ask the court to pull up the pleadings in Bille, which you will find at EF 1037, that's Appendix 2A, tab 13. The pleadings start at EF 1017, but I was going to ask you to go to 1037, which is the second page of where we deal with duty of care. I should say in Agale, just for your note, we deal with breach of duty over 17 pages from paragraph 84 onwards, EF 903. And I'm going to take you to just some excerpts of 29 pages in the Billet pleadings dealing with duty. So the preceding page, page 1036, the court will see that we set out our stall on how duty arises, and you'll see there the overlap with some of the Chandler framework. And we address at paragraph 67, under the heading control and direction over the second defendant, how we put the case. And could I just, I hope I'd be forgiven for taking this at a little speed, just flag up some of the relevant ways in which the case is pleaded under this heading. So at 67A, EF 1037, the court will see that we rely upon the existence proclaimed by the first defendant of its global policy for health, security, safety in the environment. So exactly the subject matter of these claims. And we set out an excerpt from one of their own documents. And I wonder if we can just look at that excerpt. You can see in italics, we work to manage the impact of our operations and projects on the environment and society. To help achieve this, we have a set of mandatory standards and corresponding manual that apply to every Shell company. We launched our new SSE control framework in 2009. It contains the environmental and social requirements that apply to every Shell company, as well as joint ventures where we have operational control. And then at B, little b, we move to how those are monitored. Again, this time taking an excerpt from the first defendant's website. We expect, it says in italics, every Shell company to follow the environmental and social standards and practices when operating. We define who is responsible applying these standards, and we monitor performance. And then over at 1038, carrying on, but just if we may just skip a paragraph, the Shell general principles apply to all Shell companies and joint ventures we control. We also have a set of more detailed mandatory standards and manuals covering social and environmental topics with requirements that apply to all Shell companies. And then just to drive the point home about joint ventures complying with minimum standards, we set out a excerpt proclaiming exactly that at little c from another document of the first defendants. D sets out the role of the Chief Executive Officer of RDS and the Executive Committee in implementing and overseeing the mandatory standards. Those are taken from the 2000 Sustainability Report, and I'm going to come back to that document itself. At E, we can see that there is a separate additional structure that the parent has put in place for oversight and compliance. You can see it has established a corporate and social responsibility committee, which is responsible for establishing and ensuring compliance with minimum health standards. And we set out a relevant excerpt from that 2014 report. We put in further evidence from further documents of the first defendants, RDS. This is from their website at F, about how they monitor compliance with the subsidiaries' adherence to the standards. And we can pick up a quote right at the bottom of 1039 from the website. A single overall control framework for Shell and its subsidiaries is designed to manage the risk of failure to achieve business objectives and fulfill Shell's external obligations and commitment. Shell Internal Audit delivers audits and investigations to provide independent assurance of the control framework, as well as the design and operation of the risk management system and internal controls. ethical and legal incidents are reported to the Executive Committee and to the Audit Committee. We regularly audit the HSE management systems at our facilities. Our process safety specialists do dedicated safety audits. G sets out how the first defendant proclaims that the bonuses of its senior executives are linked to its sustainability performance. And just for a cross-reference, see Lord Justice Sales at paragraph 162 of his judgment, where he identifies the potential significance of that. Little I is again stressing the first defendant's policies, but this time related directly to the unplanned release of oil. And you'll see we set out a quote that says process safety, and I'm going to show you what's meant by that, but it's essentially ensuring that the integrity, it includes certainly the integrity of oil pipelines and oil wells. Process safety is making sure the right precautions are in place to prevent unplanned releases of hydrocarbons and chemicals. We seek to ensure our facilities are well designed, inspected, maintained and operated. And then just at the top, at 1041, Shell has defined global technical standards for all projects and facilities. They're based on industry standards as well as best practice. If an incident takes place, we learn from the outcomes and embed any new knowledge into our technical safety standards and practices. And then between J, K, and L, then address a particular topic, which is responding to oil spills. And again, J deals again with the 2014 sustainability report. But if you could just note the second quote for now, that the HSSE control framework includes manuals on emergency response and spill preparedness that cover our requirements in this area. Another quote about centralized reactions and responses to oil spills at K. And then this at L from the RDS website. We manage oil response capabilities on a global scale. Shell ensures that adequate resources are maintained for managing regional and local spills. We cooperate with industry neighbours and local or national authorities. And then if you could just turn to 1042, keeping on the quote, last paragraph, response to larger skills, we use global resources and mobilise Shell staff from around the world. M deals with an expert report, Professor Siegel's report, and the report that he produced in the US proceedings. I'm going to come back to that a little later, if I may, but you'll see the robust conclusions that he reached in those reports. Paragraph 68 at 1043 then turns to security, which is a key aspect of this case, because in respect of some but not all the spills, it said that there has been a systemic failure to protect the pipeline from repeated attacks by third parties. And at 68, we turn to some of the areas in which we say the parent has taken responsibility, at least in part, for those activities. 68 little a Roman numeral 1 deals with what we say was a reorganization, not by SPDC autonomously, but rather imposed on it in respect of security. And that relates to the evidence about Miss Pickard. Can I just give you some cross references to that? See how we put it in our printed case between paragraphs 115 and 116 at EF 270. See how Lord Justice Sales, as he then was, puts it at paragraph 164, EF 486. And for your reference, the two cables, the two WikiLeaks cables, are at EF 2171 and EF 2177. Paragraph 70, back to the pleadings, at EF 1044, seeks to draw this particular section together, and it's the basis, those materials are the basis on which we avert that the first defendant exerts significant control and oversight, including in respect of security, pipeline integrity, and compliance with environmental standards. We say that the first defendant carefully monitors and directs the activities of the second defendant. The relevant, as I say, the relevant section on duty extends to about 26 pages. I'm not going to obviously take you to it all, but could I just flag up one other aspect which we deal with in the pleadings? If the court would be so kind as to go forward just the very bottom of EF 1057. We'll just do the heading at the bottom of that page, which is the first defendant's superior expertise, knowledge and resources, etc. Again, we're in the field of Chancellor. And over the page at 1058, we give some particulars of that. Could I just take you to two of those for my current purposes, starting at little c. The first defendant has created a dedicated projects and technology department within the Shell Group, which is tasked with providing advice and services to the Shell Group's operating units, including the second defendant. The P&T department is organised and supervised by the first defendant, serves as a global source of information on technical aspects of the oil industry for all of the Shell Group's operating units, including the second defendant. It's responsible for safety and environment within the Shell Group, as well as contracting and procurement. Information about the role of the P&T department is provided in Investor's Handbook, and it says this: we've created a global community of project managers to improve resourcing and build expertise by sharing best practice. The Shell Project Academy invigorates this global community. You can see how it says it does. And then at little d, the first defendant's website makes clear that the first defendant invests large sums of money through P&T departments to improve its knowledge and expertise, with the intention that this knowledge must be shared across the Shell Group. According to the first defendant's website, the research and development centres include a focus on safety and the environment and are intended to develop solutions. And you can see there from the quote underneath how that assertion is substantiated from RDS's own materials. I'm going to come back shortly to projects and technology because we now know considerably more about its centrality within the RDS group, thanks to the two framework documents I'm going to show you shortly. We would ask, we'd be very grateful if the court would, if they haven't done so already, would read the entirety of the duty section in the pleadings. Now, as in Vedanta, the pleadings place very considerable reliance on the sustainability reports, but as you would have seen, not just the sustainability reports, there are numerous documents that are relied on in the pleadings. But could I just show you, by way of example, one of those sustainability reports, which is the 2014 report. You'll find that in Appendix Part 2E behind tab 61 at EF 2281.
Mr. Hammer, before we leave the pleadings, would I be right in saying that to date you haven't made a case that the policies and guidelines themselves contain systemic errors? Well, cases that they have undertaken to do things and haven't done them. Would that be a fair representation of what you're pleading?
Well, my lord, no. At the moment, we don't have two classes of, comprehensively, we don't have two classes of documents. We don't have all the relevant policies and manuals and guidance that might have bared upon the relevant operations. And nor do we as yet have disclosure about the actual spills themselves. So just as in Vedanta, the position is identical to that in Vedanta. Something has gone wrong. Now that may be when we see all the guidance and policies, it's because there's something defective in them. Or it may be that they have not been enforced sufficiently. Now, it would put the appellants in a Kafkaesque situation if, without actually seeing and having disclosure of the full array of documentation, both about the policies and about the spills, that we had to identify in the abstract what the defects might be.
I wonder if your answer isn't no. Your answer is yes. We haven't pleaded as yet systemic errors, but you're saying that you don't have to at this stage because you need to see the whole picture.
Yes, my lord puts it exactly correctly. I'm afraid, yes, that's right. So, but that is precisely the position that I outlined in Vedanta. It would be Kafkaesque for us to have to say policy X was defective without seeing policy X, or indeed knowing precisely what caused a given spill, and it might be a mixture of all of those. And of course, as the court knows, our case isn't based purely on the policies, it's based upon a joint management.
No, your case is much wider than that. I accept that, but I was just testing the point about group-wide policies and guidelines, because what Lord Briggs said in Vedanta was that they might contain systemic errors, and that was his explanation why, as I recall, that there was no limiting principle. Merely by the existence of guidelines.
Well, and indeed, my lord, what we're going to need to do in this case at some stage, if it proceeds, is to take the full array of guidance, rules, manuals, look at the causes of the particular spills or failures to clean up, and marry the two and work out what the case is. But we start from a position in which we say there is more than a strong prima facie case that there are a range of guidelines, rules, manuals on the one hand, and there is systemic damage going on for years and years on the other. And it's either a case that those guidelines are defective, or it's a case they have not been enforced, or it's a mixture of the two. So liability can be established at any of those routes. And it can't be a question of striking out a case at this stage, because we're unable to specify which of those.
Thank you.
My lord, I was going to take you to the 2014 sustainability document at 2281. Could I start off, please, at page 2293, which is under the heading Governance and Standards? And
Lord Goldsmith, I think, wishes to raise something at this stage. Raise a point. Lord Goldsmith.
My lord, I don't know if you can hear me, and I don't know whether you've heard what's just happened. I can't hear you, and I wasn't able to hear Mr. Hermer. There's some alarm has just gone off in the building where we are. I'm very unhappy about that. We're trying to investigate at the moment, but unfortunately I haven't heard the last minute or two of what Mr. Hermer said.
Right. Can you hear me now, Lord Goldsmith?
Just investigating. The alarm system here went off.
Yeah, can you hear me now? Can you hear me? Mr. Sheck, can you contact Lord Goldsmith to see what's happening?
I can't hear my lord.
Yes, I will do so now.
Yes. We will pause for 5 minutes for this, or for 2 minutes while this is being sorted out.
Thank you, my lord.
Good morning. We are resuming the hearing in the appeal by Okpabi against Royal Dutch Shell Plc. We were interrupted by a fire alarm. Lord Goldsmith, I think you lost the last minute or two of the exchange, which I think I can summarize very briefly. I raised a question whether or not the appellants had pleaded not only that there were group-wide policies and guidelines, but that those policies contained systemic errors. And the response was that something had gone wrong, and there were two possibilities. One was defective policies, the other was that they hadn't been enforced sufficiently, and one couldn't be expected to plead which of the two at this stage, what was the cause, until one had access to further internal documents. I hope that's a fair summary of your position, Mr. Hermer.
Yes, my lord.
Thank you. And you are moving on to the governance and standards document at page 2293.
Yes, my lord. It's the 2014, to say Lord Goldsmith has the reference, it's the 2014 Sustainability Report. So that's Appendix 2E, tab 61, starting at 2281. And then I was just going to take the court to a few excerpts starting at 2293 under the heading Governance and Standards, and just flag up a few points from this page, if I may, starting at the beginning, which is its statement that effective governance standards and controls within Shell help to ensure good sustainability performance and health, safety and the environment, and our work with communities. And it says this: our governance procedures are applied to all areas of decision making across Shell. This involves the board, 4 board committees, the executive committee and the teams and individuals who work in our operations. And then this: we take rigorous care to ensure that decisions are cascaded within the business. It introduces thereafter the Corporate and Social Responsibility Committee. But could I address your attention to the column on the right-hand side, shaded in grey, under the heading Our Standards, where it says the overall accountability within Shell lies with the Chief Executive Officer and ExCo. Our standards are established by our HSSE Performance Executive Team. We could then just drop a paragraph to our standards are set out in the HSSE control framework, supported by a number of guidance documents. They apply to all Shell companies. The control framework defines standards and accountabilities at each level of the organisation and sets out the processes and procedures that people should follow. The rest of that box then deals with another separate layer of assurance and auditing. And we can see from the bottom of that column, outcomes from these audits and the response from Shell's management are shared with the relevant parts of Shell and the Corporate Social Committee. The actions taken to address the audit's findings are also monitored in Shell. Can I then take you to 2295, which is a heading Safety. And in the middle column, you'll see a heading Process Safety, term we've already seen. Process safety is making sure the right precautions are in place to prevent unplanned releases of hydrocarbons and chemicals. We seek to ensure our facilities are well designed, inspected, maintained and operated. You may recall this from the pleadings. Shell has a defined global technical safety standards for all projects and facilities. These are based on industry standards as well as best practice. And the next paragraph, we ensure that plans are in place and adequate resources are maintained for dealing with incidents such as spills, fires and explosions. We routinely practice and review our emergency response plans. And then next paragraph, our ability to manage oil spills has been enhanced by our global response network. That's process safety. Environment is on the next page, 2296. Just highlight a few passages, if I may. Starting again at the top, we carefully consider the potential environmental impact of our activities and how local communities might be affected both before projects begin and during operation. Our environmental standards focus on key areas such as managing emissions, etc. And then you'll see preventing spills and leaks and conserving biodiversity. We work to manage and minimize environmental impact from our operations. And then under the heading Our Standards, our approach is to comply with the environmental regulation, to continually improve our performance in line with best practice, and to prepare for future risks and opportunities. We draw on external standards and guidelines for the World Bank and others, Our own strict environmental standards are designed to meet or exceed regulatory requirements. They're detailed in our HSSE framework. Shell standards are applied to joint ventures that we control. And you'll see, I don't take you to the details now, but you'll see also, there's in the middle column, their approach to sensitive environments. At 2300 is the heading Communities, and where we're told that community engagement is fundamental to their approach on sustainability. Last paragraph in the first column, we develop a social performance plan for all our major projects and sites. These plans follow the control framework which governs how we plan and operate. We also use international standards as our benchmark. Our engagement with communities and social investment projects are measured against our social performance indicators and then analysed within Shell. Nigeria is one of two countries that are expressly mentioned or have their own pages in this report. You can see the Nigeria page if you turn to 2318. And you can see that it deals expressly with spills and responses in the little grey column on the right-hand side of the page. And you can see from the first paragraph the very high number of spills and the high percentage of those caused by theft and sabotage. And then the statement in the middle paragraph that a key priority for Shell globally is to achieve the goal of no more operational spills. All of that in a box that is expressly and exclusively focused on Nigeria. And we can see the particular role that oil spills in Nigeria play from two other sources in this document. The first is one you will find at 2327, which is under the heading Safety. And under the subheading Process Safety, you will see this. Since 2011, we have introduced reporting of process safety in line with industry standards. And you'll see 2014 best ever performance, both tier 1, that's lower level spills that move up to tier 3, which are huge, vast spills. And then you'll see this. For Nigeria, process safety events related to sabotage and theft are recorded separately. To help improve performance and investigate in this area, we investigate and learn from incidents, small and large. So there appears to be a separating out of Nigeria and oil spills from Nigeria from the rest of the world. And that is a point that is made even clearer if the court would return to page 2334. And what we have on this page is certain amounts of data relevant to sustainability targets within the Shell Group. And if you go down 6 columns, you'll see one of those indices is spills and discharge. And you'll see third item, operational spills by volume, and then also operational spills by number. And I'd ask you to note two things. Firstly, Nigeria is articulated separately to all the rest of the world within the Shell Group. And then you will also notice that in some years, the figures for volume of oil spilt in Nigeria far exceeds that on some years for the rest of the world combined. That's a sustainability report. You'll see from the pleadings that there are references not only to other sustainability reports, but other Shell RDS documents, including their website and other published material. At the time we pleaded this case, it was all based upon information in the public domain. But what I'd now like to do is to look at two documents that we didn't have at the time of pleading the case, or indeed at first instance. But in fact, if I could start before that, actually, with the other important source of evidence that the appellants relied on, and those are the witness statements. Now, those are the statements of a Mr. Sticko. For your reference, his statement is at EF 1869. He worked at RDS headquarters for about 6 years. Mr. Briggs, EF 1855, worked in a multitude of Shell entities over a 38-year career with the Shell Group. And Miss Sedgwick, EF 1899, who was the SPDC security lead. There's a further statement from Professor Siegel. I'm going to deal with that later under the heading of disclosure, if I may. Now, my lords, my lady, in light of time, I'm not going to take you to the statements themselves. We deal with them in writing from paragraphs 96 to 111 of our printed case. They are also described, particularly that of Mr. Sticko's, in some detail in the judgment of Lord Justice Sales, between paragraphs 154 and 168. We would respectfully ask the court to read each of those statements carefully. It's very rare to have evidence of this nature at this stage. They are, as Lord Justice Sales noted, whistleblowers. And we submit they provide first-hand evidence of the centralised nature of the RDS group, of the variety of different interventions in fact exercised by the top of the organisation. They evidence the particular concerns that SPDC cause RDS, as well as evidence of specific types of intervention in the operations relevant to this case, not least security. And they also demonstrate that RDS's promulgation of detailed mandatory requirements, policies and manuals were expected to be complied with by SPDC. Now, as I said, in addition to these statements, which are in themselves, we say, capable of deciding this appeal, simply on those statements themselves. But in addition to them, there are two other key documents before the court that were before the Court of Appeal that weren't available when we pleaded the case or before the first instance proceedings. And I take the court to them, not only because of their contents, but also because the way in which they emerged in these proceedings underlines the need for caution before summarily dismissing claims of this nature. And I should also note there was nothing equivalent to the two documents you're about to see in Vedanta. The first document is called the RDS Control Framework. It is the principal governing document describing how the Shell group of companies are managed. And we only learnt of its existence after the first instance hearing because it was provided to us by Miss Sedgwick. The respondents vigorously opposed its admission into evidence. Now, we describe the key features of this document between paragraphs 68 to 73 of our printed case. Can I just flag up a few of them? We are still in volume 2E, this time behind tab 55. It starts at EF 2237. And if I could ask the court to turn to page 2239, which is the introduction. And you will see from the second sentence of that onwards that it is the single overall control framework that applies to all Shell companies, i.e. PLC, and all companies in which PLC either directly or indirectly has the controlling interest. Shell companies designated the operator of the joint venture apply the framework to the operation of the joint venture. Now, in Annex A to the respondent's printed case, they refer correctly to this document as akin to the constitution of the Shell group of companies. For your note, that's at EF 357. Of Court would be so kind as to turn to page 2240, the next page. Heading shell control framework on a page. Can I just do it in 2 paragraphs? The first is the third. Shell is organised in a way that helps to meet its business objectives while meeting statutory and legal requirements. The board, chief executive and executive committee have defined accountabilities and authorities and set the overall strategy objectives and the boundaries within which these are achieved. This includes approval of the Shell control framework. And then this, Shell internally organises its activities principally along business and function lines. It transacts its business through legal entities. The CEO and the business and function heads allocate resources in line with strategy and plans, and they also delegate authorities into the organisation. Last paragraph on that page, where major risks are present that require common treatment across the Shell group, the risk response may be to define standards as mandatory rules. Manuals provide more detailed manual instructions on how to implement standards or other parts of the Shell control framework. A control risk typical for routine risks is for business and functions to design and operate controls. Controls help to assume that risks are managed in a fit-for-purpose manner and objectives are achieved. It's management's accountability to demonstrate that controls are well designed, documenting and operating effectively. Assurance activities are there to provide comfort that risk management and control activities are working as intended. If we could then go, please, we get to 2242, we get a little more insight as to what the group standards and operating standards and manuals are. Standards and manuals is the heading at the top of that page. Standards and mandatory rules establish where major risks are present that require common treatment across the Shell group. Senior leadership is accountable for the implementation and consistent application of relevant standards. You can see group standards is the next heading, and they're adopted for matters that present significant group level risks or matters that are subject to external stakeholder expectations and external disclosure. They also establish mandatory rules as to how to comply with legal and regulatory requirements. Operating standards, the next heading, define mandatory rules that are needed in addition to the group standards. These standards are approved by the relevant business heads. Manuals provide more detailed mandatory instruction on how to implement group or operating standards or other foundation components. And then the next paragraph is in the technical area. The technical practices establish requirements for all design, engineering and construction activities, as well as the operation of assets and wells. The technical practices are approved by the relevant technical function head or global discipline head. Technical requirements related to process safety, and I've shown you what that means, are mandatory for all projects, well activities and asset operations. We get a further insight into controls if we turn to page 2245. Under the heading Control and Assurance Controls, management puts in place and maintains controls to help ensure it will achieve its objectives and fulfill its external obligations and commitments. We could then just drop a paragraph. Effective controls are integral to managing business and to sustaining its performance. Controls are operated throughout Shell in all business and functions at various levels. They range from ongoing transactional checkpoints designed into systems and processes to regular management reviews. Controls are continuous structures, activities or mechanisms that help ensure businesses and functions achieve their objectives, including compliance. In short, they modify risks. I just ask you to note at 2246 the description of independent assurance within the group, and at 2247 the role of the board. And if I could take you to 2248, under the heading Chief Executive Officer, you'll see there a table that sets out a small number of principal responsibilities for the CEO. You'll see the second is risk management, and the third is management of asset integrity and process safety. And if you look under Executive Committee, second paragraph, the CEO and the Executive Committee, under the direction of the CEO, are responsible for the identification and evaluation of risk consideration by the board, implementation of board policies on risk control, management of risks, and the safe condition and environmentally responsible operation of Shell's facilities and assets. So it's clear we submit that this isn't simply a question of the board and the CEO having general overall responsibility for everything. They are at the apex of sustainability by design. We learn a little more about businesses and functions and how the nature of the vertically integrated business that the Shell Group is at 2249. In order to, under heading businesses and functions, in order to optimize its operations in different business sectors and across national and company boundaries, Shell internally organizes its activities principally along business function lines with supplementary arrangements to take account of country and regional perspectives. Next paragraph, business and functions are portfolios of activities and responsibilities operating according to common objectives and strategies with formally delegated organizational mandates. The businesses, and it lists the businesses, but note there they include upstream and projects and technology. And if we turn over to the page 2250, we get a little more about what they are. So upstream, we can see, includes businesses that explore for and extract crude oil and natural gas, so that we're dealing with SPDC. And projects and technology, and that's still in that first box, is overall accountable for wells and engineering and well completion, for project execution. It drives the research and innovation to create technical solutions and competitive IT, provides technical services and technology, capability covering both upstream and downstream activities. It's responsible for providing functional leadership across Shell in the areas of safety, environment, and sustainable performance. And then if you go to the last two paragraphs on that page, outside these three functions having been dealt with in the box above, there are other functional areas which also address matters which present group-wide risks to the establishment and maintenance of appropriate standards, practices, and oversight. These include safety and environment, sustainable development, and they reside, as you can see, in projects and technology business. The technical functions have been allocated similar responsibilities to address technical issues. And you can see that these are development, discipline engineering, and they include process engineering, projects, research and development, safety and environment, upstream production and wells. And finally, on this document, just one other paragraph, we'll pick up at 2253. First substantive paragraph starting, Shell has an integrated, consistent process to delegate authority from PLC and other Shell company boards to organisations, individuals and committees. The objective of delegating authorities is to ensure that decisions are made at the appropriate level in the organisation and that the transactions are carried out by the appropriate company. The controller is the custodian of the delegation authority process. That's the RDS control framework. As I say, it came to us only because after the first instance hearing, Ms. Sedgwick came forward and provided us with a copy. I would ask in due course the court to read both the first statement of Mr. Brandeis for RDS and Mr. Ockenboer for SPDC. You will see no mention of this document that is now accepted to be essentially the organisational constitution. You will see no mention of the executive committee. And it is very difficult to read their statements, we say, as providing anything close to a comprehensive description of the organisation that they were purporting to give when seen in light of this control framework document. Could I then just turn to the HSSE framework, unless...
Do you have the page numbers of those witness statements, Mr. Herman?
I'll provide them to, I'm so not immediately at hand, I'm so sorry, I'll provide them to my lord.
Thank you very much.
Oh, yes, I'll provide them to my lord. Now, can I turn then to the HSSE, somewhat confusingly also called control framework document. So it's the HSSE document I'm going to refer to it as framework document. This was disclosed during the third day of the hearing before the Court of Appeal, notwithstanding substantial resistance by the respondents. What we were given was the complete version, as we understand it, of that document. Prior to that point, only 2 of its 220 pages had been disclosed as an exhibit to Mr. Brandeis' first statement. Now, this framework document is one of only 2 documents not in the public domain that have been disclosed by either respondent in these proceedings relevant to the question of duty. The only other document is the operating agreement for the pipeline, which is a 1991 document. And the suggestion that we've been provided with anything else is wrong. Now, the framework document is at 2H, tab 91, EF 3191. Also, a very helpful guide to reading and understanding it is a glossary, which is behind tab 92, starting at EF 3415. As the name suggests, this is a general framework which reveals the existence of scores of additional documents not in the public domain. And if the court were to turn to page 3192, you will see from that and the following 2 pages that it provides manuals for a range of relevant activities, relevant to these claims activities, such as process, safety, security, and the environment. I'm just going to show you, if I may, 3 particular manuals contained within this framework. The first is in respect of emergency responses. So this includes, as I'll show you, responses to spills. And we can see that, please, at EF 3232. You can see the heading here, emergency response management. It provides a structured system for letting those within the organisation know with relevant responsibilities what those responsibilities are. You can see that its purpose is stated to be to plan and prepare emergency responses to incidents that mitigate the consequences. I'm going to show you who it's for in a moment, but you can see the situations that are not covered. And emergencies, you can see, are defined as including, from the second line, end of second line, incidents and oil spills. And you can see that there is an additional requirement for dealing with spills for water. Those additional requirements are the 2 pages, aren't these pages, they are the 2 pages that were exhibited to Mr. Brandeis' statement. This deals with oil spills generally. If we can just go back up to see who it's for, these are all terms defined in the glossary, or those in colour are. Business leaders are defined as people who are responsible for a whole business, and I've shown you what the business means. Country chairs are people who are appointed by regional directors. So the country chair in this case, as you will see from SPD's evidence, happens to be the managing director of SPDC, but he's not there in that capacity. It's a Shell Group capacity. You can see it includes a vice president for health and safety technology and managers. Managers are defined as people appointed by the business leaders to be in charge of a particular asset. The requirements are imposed on these various individuals. You can see for a business leader, they've got to establish point 1 under requirements. They've got to establish and maintain a country emergency response plan. The top of 3233, we can see that there are a number of obligations that are imposed upon the, amongst others, the Vice President for HSE Technology, which include at 3 bullet point 1, establishing, maintaining a process for conducting emergency response reviews. At bullet point 4, for establishing, maintaining core competency requirements for key incident management roles. And at the last bullet point under 3, for training and frequency context for the incident management teams. And at 4, we learn of the existence of the Oil Spill Expertise Centre, who have plans involving spills to water, and the Centre for Expertise for Emergency Response to approve alternative response. We can then see from paragraph 5 onwards that very detailed obligations are imposed upon the manager in respect of compliance with the centralised mandatory rules for dealing with responses to oil spills. Could I just show you how it deals with security? And that's at 3352. Sorry, I should have noted, we don't need to go back to it, but Oil Spill Expertise Centre and the Centre for Expertise for Emergency Responses are all the type of things one would want to have disclosure to see who they are and what they do. Security 3352, you can see the purpose is to manage security risks by assessing security threats and providing controls to safeguard people. It goes to country chairs, to managers, and to the Vice President of Corporate Security. And we can see under requirements for the country chair or manager, when no country chair is in place, for example, at 2, to develop plans with the support of corporate security, review and approve the country security threat, execute the country security risk management plan in line with the country security threat. The manager, under 6, has to develop and maintain security plans with the support of corporate security. And at 11, the Vice President of Corporate Security has to establish and maintain risk protocols and conduct and keep the level of country security threats assessed and country security threat levels under review. All of this, when you come to the statement of Ms. Sedgwick, you will see is consistent with what she says. So there is a centralised corporate security. Again, that's going to be obviously a subject of relevance when it comes to disclosure and evidence. It's centralised. Finally, on this document, can I just give you an example that is relevant to the issue of mandatory policies governing the pipeline? And there's a section on design and engineering, which you can find back at 3300. And you can see the purpose is to define process safety requirements in technical standards for design and construction that have a direct relationship to the control process of hazards. You can see some of the familiar capacities to whom this is addressed: a business leader, asset manager, project managers, and well managers are all defined as being within the business, but they're local, generally local people, but acting in the business capacity. There's something called a technical authority and design engineering custodians. And you can see that what this covers, this manual section applies to company assets, and you can see bullet points 1 and 2, wells, pipelines. There's one particular requirement I just want to draw your attention to on this document, which is you'll see on 3301 requirements, the asset manager, project manager, or wells manager is accountable for 1, applying the process safety design and engineering requirements that are indicated in the Shell Design and Engineering Practices, DEPs, listed in Table 1, whenever designing or constructing new assets or making permanent or temporary modifications to existing assets. And that list of DEPs is set out at 3303 and following pages, and you will see that they set out a whole range of depths dealing with engineering. Very many of them on their face appear to be applicable to the wells that are causing the damage and the pipelines that are causing the damage in these 2 pleaded cases. But you can see them pulled together, and indeed there appear to be more if you would be so kind as to go to volume 2F behind tab 70 at EF 2679. This is something called a depth specification global technical standards index. And you can see if you go to 2681, under the contents, the headings, you can see that many of them are on their face of it relevant, including petroleum engineering, pipelines, process engineering that you've already seen, technical safety engineering, etc. I'm just going to give you an example. If you turn to 2690, you'll see that under the pipelines flow insurance at the bottom of that page is the heading. At 2691, it sets out a whole list of DEPs, including pipeline integrity, pipeline leak detection, pipeline repairs. My lord, I'm in your hands as to whether you want to take a break at this point or whether I can continue.
I think there was some repair to be done relating to your system, if I remember right, that Mr. Sheck wanted an opportunity to sort out. So if we can have a shorter break as possible,
Of course.
Return in 5 minutes' time.
Of course, my lord.
Thank you very much. Good afternoon. We are resuming the hearing of the appeal in Okpabi against Royal Dutch Shell Plc. Mr. Hermer, you continue your submissions.
Thank you, my lord. I think we lost about 15 minutes because of the technical interruption earlier. I'm hopeful I'm going to make up some time, but I'd be very grateful if I could have a little latitude if I go over. But I'll try and be as concise as I possibly can.
Yes, well, I think in the circumstances, some latitude is called for. Thank you.
Thank you very much. So those are all the documents I wanted to show the court. Can I just pull them together with the witness statements and the pleadings and make 4 points? Firstly, this is clearly a highly vertically integrated group of companies organised on business and functional lines which cut across corporate entities. Consistent with this is it appears that RDS delegates its own power and authorities to other committees and companies and individuals within the group, but all under a structure in which the RDS CEO and executive committee are expressly said to be responsible for the management of asset integrity and process safety throughout the group. As I have said, the CEO and ExCo are at the apex of a centralised HSSE system, and they play a proactive role in its implementation and enforcement. Secondly, through both the Projects and Technology Business Division, which is a centralised hub of expertise, and the other relevant function and businesses defined in the control work, they impose mandatory policies, guidelines, manuals and instructions that govern the operations most relevant to the claims, and they provide mechanisms for monitoring and enforcing compliance with those mandatory documents. Those various policies, guidelines and centralised system suggest not simply a high level of advice and supervision, but the instigation of systems and practices governing granular detail, down to the level, as Lord Justice Simon noted at paragraph 101, of mandating the type of weld to use when repairing a pipeline. 3, although our case is not based on policy alone, even seen in isolation, they give rise to an arguable duty, reflecting a real dispute that liability could said to be arise on any one of the 4 Vedanta routes that we identify in our printed case, including Route 4. RDS have proclaimed to the world that they ensure that the standards are in place and are enforced, and it is at least arguable that they should be held to their word. My lord asked me earlier about the defence, and I set out a position, but we do, as to, I beg your pardon, the defectiveness of the policies. I should just, for your note, we do give a concrete example in our printed case of at least one area in which a defective policy has resulted in lasting environmental damage. And that is at paragraphs 112 to 114 of the printed case, in which we discuss the findings of a United Nations report, which looked at Ogale, and that found that the particular type of clean-up technique employed by SPDC was one that was in place pursuant to instructions from a part of the centralised projects and technology group. And that we relied on the findings that a methodology imposed from above failed to achieve the environmental cleanup or legislative compliance. So we give an example. My fourth point is that the two framework documents that I've shown you underline the importance of disclosure. Neither were available at first instance. Had we not appealed, we would never have known of their contents. And they also underline the need for caution for accepting the evidence of one side's witnesses at an interlocutory stage. As Lord Justice Sales noted at paragraph 168, the two framework documents proved to be confirmatory of the evidence of the claimant's witnesses. And by contrast, they are difficult to reconcile with the description of the relationship given by Mr. Brandeis and Mr. Okpabi. My Lord, the references to those, Mr. Brandeis' first witness statement, you'll find at EF 1657, his second witness statement at EF 2025, Mr. Okpabi's first witness statement, EF 619, his second at EF 2051. I've already made the points as to what is not contained in those statements, which we do ask the court to read. And you will also note that there is verbatim replication of the language between the statements of those two individuals. So these are clearly very carefully drafted statements. My Lord, that's all I intended to say about the evidence and how the appellants put their case. Could I turn to the fourth of my 5 sections, which is what we respectfully submit with the errors of approach in the majority in the Court of Appeal? You'll see that we identify 7 in our printed case from paragraph 30 onwards, and we maintain that each is sufficient to vitiate the majority's decision and justify the court's intervening on its own. But for the purposes of my oral submissions, can I amplify 3 critical errors that we respectfully submit were present in the majority judgments and how they materially impacted upon the fair analysis of the evidence? And those are these. Firstly, their conclusion that a parent could never incur liability simply by the laying down of group-wide policies. Indeed, the conclusion that the very structure of a multinational corporation inures against the existence of a duty. Secondly, their application of a test of liability for the acts and omissions of a third party that was exclusively directed to the question of control. And thirdly, their refusal to take account of the potential impact of future disclosure. Could I start then with group policies? As I've already noted, the judgment of Lord Justice Simon between paragraphs 86 and 117 contains a description of many of the documents in the possession of the claimants, which he accepted imposed a centralised system of mandatory standards and mandatory requirements. And as I just noted, even down to the level of the type of weld that should be applied. But the heart of his lordship's rejection of these policies as evidencing legally relevant intervention was that they were global mandatory policies imposed by the parent rather than bespoke policies applicable just to that subsidiary. And this is absolutely central to his lordship's reasoning. Can I just show you that starting first at paragraph 89 in his lordship's judgment at EF 469. where his lordship says it's similarly important to distinguish between a parent company which controls or shares control of the material operations on the one hand, and a parent which issues mandatory policies and standards which are intended to apply to a group of countries in order to ensure conformity with particular standards. Obviously, as I know the court knows, we put it in both ways. The issuing of mandatory policies plainly cannot mean that a parent has taken control of the operations of a subsidiary, and necessarily every subsidiary, such as to give rise to a duty of care in favour of a person or class of persons affected by the policies. And we see this as the crux of his lordship's analysis. If we move on to paragraph 121, where he comes to his conclusions on proximity, where his lordship says, secondly, and crucially, the extracts relied upon reveal a centralised system based on industry standards and their own best practice. They're to be found in the control framework, which provides for consistent mandatory standards throughout the Shell Group. To the extent they established mandatory requirements, they were mandatory across the Shell companies. And then at the bottom of that paragraph, all this, as one might expect, of best practices which are shared across a business operating internationally. And we can see, again, further emphasis of the centrality of the fact that these are global rather than the bespoke policies. If one turns to 123, because as you can see from that paragraph, it forms the basis for his explanation as to why nothing in the HSSE framework assists the claimants on the question of duty, because they're going to everyone. And again, you can see that at paragraph 126, because his lordship considers that even such material as there was as to the particular focus of Nigeria on the minds of RDS, that's not enough. That's insufficient to add to the global policies to get you home on duty. Presumably, had there been more in his lordship's mind, it might have been. And we can see yet again the centrality of this to his lordship's analysis. If we turn to paragraph 128, where his lordship is addressing the trial judge's treatment of the third limb of Caparo, whether fair, just and reasonable. And just below letter H, you can see he's identifying the fourth reason that the trial judge relied on. Imposing a duty of care on RDS would potentially impose the indeterminate liability that Justice Cardozo famously spoke of. And if one turns to 129 on page 477, you can see how his lordship deals with it. Above letter B, I would accept the fourth point, at least to this extent. Much of the claimant's argument was designed to show the Shell Group imposed a wide-ranging degree of direction from the centre. However, in my view, the argument proved too much in the sense that what in fact showed was the standardisation of policies and practices across all the operations and in all the countries in which the Shell Group operated. The Chancellor adopted a similar but not entirely identical analysis. You can see his rationale developing at paragraph 195 of his judgment, where his lordship noticed that the documents demonstrate rather what I would expect from a commercial, I beg your pardon, I would from a commercial perspective expect. It laid down detailed policies and practices as the management, oversight and engineering, which they expected their subsidiaries and joint ventures to apply. The Nigerian subsidiary was only special because it had particular problems and particularly important from an economic perspective. The detailed policies and practice do not seem to have been tailored specifically for SPDC. Rather, they all apply across the board to all RDS subsidiaries and joint ventures without distinction. It's already been said it'd be surprising if an international company were to owe duties to those affected by operations of all its subsidiaries. And I think then, that there needs to be something more specific for the necessary proximity to exist. You can see more of the rationale for this at 196. His lordship explains that I believe is the case because it would be surprising if a parent company were to go to the trouble of establishing a network of overseas subsidiaries if it intended itself to assume responsibility. The corporate structure itself tends to militate against the requisite proximity. And this is a theme which his lordship returns to under the just and reasonable limb, at paragraph 206 of his judgment at page 499, right at the end below letter C, I'd very much pray and aid the unlikelihood, which I've already mentioned, of an international parent like RDS undertaking a duty of care to all those affected by the operations of its subsidiaries. Can I just make three short submissions? Firstly, an analysis based upon a conclusion that mandatory global policies are incapable of giving rise to a duty is simply incompatible with Vedanta, in which in paragraphs 52 and 53, my Lord identifies three non-exhaustive ways in which group-wide policies could give rise to a duty. Consistent with Vedanta, we submit that a duty cannot be determined by a quantitative assessment as to how many legal personalities are required to follow mandatory policies, but rather a qualitative assessment that includes looking at the contents of those policies, how they were understood to be applied by both parent and subsidiary, and how, if at all, they were enforced, and also the nexus between those policies and the acts or omissions said to have caused actionable loss. Those are the relevant questions. Secondly, the analysis of the Chancellor, and by implication Lord Justice Simon, that the structure of a multinational corporation militates against proximity, is again impossible to reconcile, we respectfully say, with the conclusions of Lord Briggs at paragraph 54 of Vedanta, that there is nothing special or conclusive about the bare parent-subsidiary relationship. Flowing again from my Lord's analysis at paragraph 51, that there are no limits to management models in groups of companies. Now, there is nothing in either judgment of the Chancellor or Lord Justice Simon to suggest that their conclusions are based on a specific analysis of the Shell Group. Rather, it's quite clear they were applying their conclusions to multinationals as a whole. And simply by way of side observation, we would note that if the Chancellor's conclusions on this point were right about the nature of multinational corporations and were to be adopted, it would point the development of English tort law in the opposite direction of travel to other jurisdictions and other international law developments, as eloquently described in the intervention of the Core Coalition and the ICJ. Third point is the Chancellor goes even further in paragraphs 196 and 206 by appearing to suggest that the intention of a parent company may be relevant in determining whether a duty exists. Now, of course, I entirely accept that it must be very doubtful that RDS intended to assume legal responsibility for those living in the Niger Delta, but the intent of the tortfeasor is not a governing principle in the law of negligence. The relevant question is whether by their actions responsibility can be said to attach to RDS. See for your notes to this effect, Lady Justice Arden, as she then was in Chancellor, Authorities 4, paragraph 64 at EF 3780, where she held that the test might be more properly understood as attachment of responsibility rather than assumption of responsibility. Could I then move to the second area of critique of the judgment below, which is what we say was the over-narrow test of control that was applied? Both Lord Justice Simon and the Chancellor approached the question of duty by application of that singular test of control. It's the only one that Lord Justice Simon applies, and he utilises it frequently to assess and calibrate the evidence. See, for example, paragraphs 89, 124, 125, 127, and see the Chancellor at 205. And it appears to be a test of a high level of control and a high level of operational control. Can I make two submissions on this test? Seen obviously with the great advantage of this court's judgment in Vedanta, it is clear that the test of control is not the exclusive metric for the assessment of duty. It is one of a number of terms that might describe acts by a parent company sufficient to give rise to legal responsibility. The question, as my Lord Briggs identifies at paragraph 49 of Vedanta, is the extent to which a parent avails itself of the opportunity to either take over or intervene or supervise or advise. It's not simply control as the governing test. Secondly, although neither Lord Justice Simon nor the Chancellor define precisely what they mean by control, it is clear that they identify a high level of operational control, which is too high a threshold, we submit, for legal responsibility to be engaged. They accept that the evidence of RDS imposed mandatory rules governing pipeline repair down to a weld, and it is very difficult in those circumstances, we respectfully submit, to see why either literally or legally that does not arguably amount to a form of control sufficient to engage legal responsibility. If I'm telling you, when you are repairing a pipeline, what materials you need to use and how you need to weld it, then it is very hard to understand why that cannot be classified as controlling you. It is also, with respect, difficult to understand how the Chancellor could properly have reached the conclusion that he did at paragraph 205, that the mandatory requirements and standards were not imposed by RDS. It was not in dispute that the requirements and standards were promulgated by RDS, and as you've seen, they are expressly described as being mandatory. And that in itself, we submit, gives rise to a prima facie inference that they were imposed, in the sense of it being something that SPDC was compelled to comply with. Moreover, the evidence I've taken you to, including the existence of detailed reporting lines of audit and insurance teams and stressing the responsibility of the board and the chief executive, make it clear that there was a sophisticated system, it is a sophisticated system, set up by RDS to monitor and compel compliance with those mandatory requirements and standards. These errors, we respectfully submit, the two errors I've identified, and the other 5 set out in our printed case, cannot be explained away simply by one view that anybody's entitled to come to on the evidence, nor can they be categorised as inconsequential. They plainly impacted upon the assessment of the evidence in a way that vitiates the conclusions. As the respondent itself accepts, see paragraph 4B to Annex A of their printed case EF 355, the Court of Appeal made concurrent findings and legal conclusions. If one rejects out of hand global policies as legally relevant, one cannot fairly examine the extent to which they may or may not demonstrate the degree of intervention necessary to establish a duty. If one applies only a test of high control, then the legal significance of evidence reflecting other types of relevant intervention will be overlooked or misunderstood. And we respectfully submit there is no more telling reflection of this than the rejection by the majority of the evidence of the witnesses. How else, we ask respectfully, but through the application of the wrong test, could Lord Justice Simon conclude, as he did at paragraph 72, that the long detailed witness statement of Mr. Sticko only gave scant support to the claimant's argument, or at paragraph 73 that the evidence of Mr. Briggs was slight. So too, we respectfully submit the Chancellor's narrow analysis explains his treatment of the witnesses. He dismisses the relevance of Mr. Sticko primarily on the basis that it suffered from the same defects as the documentary evidence, in that it didn't really address Nigeria, or insofar as it did, didn't provide evidence that RDS actually did control SPDC. And his lordship also, the approach also explains Lord Justice Simon's refusal to admit Miss Sedgwick's evidence and the Chancellor's belittling of it at paragraph 202. Now, once the witness statements are read, with the great advantage that, of course, their lordships below did not have, of the clarity provided by Vedanta, then their exclusion or belittling does not survive. Can I move then to the third error that I wish to amplify in oral submissions, which is in respect of disclosure, and the refusal to countenance the impact that future disclosure might have on the assessment of the case. We can see Lord Justice Simon's approach to this in 2 places. Firstly, paragraph 82 at page 468. This is looking. He first deals with a submission that the witness statement of Professor Siegel might demonstrate what may yet come on disclosure, which His Lordship accepts it's possible, but says this: the prospect of further evidence relevant to the existence duty does not assist on the present appeal, which must be decided on material available in accordance with the relevant test. And then again at paragraph 122, starting at 475, but the relevant bit is at top of 476. Although the claimants may make a further point, it's illustrative of what may emerge on disclosure. The difficulty is jurisdiction is founded on a properly arguable cause of action and not on what may or may not become a properly arguable cause of action. The Chancellor at paragraph 182 sets out a test that there must be, by letter G, a clear prospect that new material will become available, which is likely to give the claimants a real prospect of success at trial. But then at 205, without any, respectfully say, without any real explanation, concludes that all the claimants could be expected to receive on disclosure would be more high-level guidance unrelated to specific dealings with SPDC and thus incapable of making out a duty. Can I briefly identify 5 reasons why this approach was wrong, both as a matter of principle and why it was also particularly unfair in this case? Firstly, whereas here there is a real dispute as to the level and nature of the relationship between 2 corporate entities, it is, as my Lord Briggs said at paragraph 44 of the Danta, blindingly obvious that the relevant factual inquiry will turn on the contents of the documents and the communications passing between the 2 companies, all currently unavailable, but all in due course disclosable. And this reflects in turn what Lord Bingham said in the case of Lubbe in the passage set out at paragraph 29 of our printed case, EF 224, that disputes about a parent's alleged liability will inevitably turn on documents that are not in the possession of the claimants at the outset of the case. And connected to this is a curiosity in this case, is that at the outset of the jurisdictional challenge, we had understood RDS to implicitly accept the proposition that the question of whether or not a duty of care could arise could only be fairly determined after disclosure. And that's because, as we set out at paragraph 14.2 of our printed case, they proposed that there be a preliminary trial of the question of RDS's duty prior to determination of jurisdiction, which they accepted would require full disclosure before it took place. Secondly, we are able not simply to rely upon an abstract likelihood of further relevant documents, but we can list potentially highly relevant categories because some of their existence has been highlighted by reference to documents in the public domain. And you will find a non-exhaustive list of 20 categories of documents between paragraphs 123 to 124 of our printed case EF 273. Third point, we served evidence from Professor Siegel, who has actually had access to many of the highly relevant documents dealing with the Shell corporate structure and its relationship with SPDC. We would respectfully ask the court not only to read his statement, but also his US report. Can I give you references to both? His statement is at 2C, tab 36, EF 1835. His US report, 2F, tab 73, EF 2737. You will see that Professor Siegel was an expert in the United States proceedings, in which he was given access to over 200 internal Shell company documents, and on which he based his very strident conclusions about the nature of the relationship between the 2, the control exercised by RDS, and why that meant that he strongly disagreed with the contents of the statements of Mr. Brangeis and Mr. Ockenbohr. Now, it may well be that the robust conclusions he reaches in his report would be that at trial, the province of the judge rather than an expert. But as Lord Justice Sales points out at paragraph 169, what Professor Siegel's evidence demonstrates, if nothing else, is that a large number of documents not presently in the possession of the claimants may well be capable of demonstrating the requisite level of intervention by RDS over SPDC, And we would respectfully say there is no real explanation to exclude Professor Siegel's evidence by either Lord Justice Simon or the Chancellor. Lord Justice Simon deals with it at paragraph 74 and the Chancellor at 204, but it is merely dismissed on the unexplained basis that it's opinion evidence. The proper basis on which it was sought to be introduced was that identified by Lord Justice Sales. And even if it is opinion evidence in some respects, that doesn't make it inadmissible for demonstrating whether or not an arguable case may exist and the relevance of future disclosure. Fourthly, fourth point is that another curiosity in this case is that in ongoing proceedings in Holland, the Dutch Court of Appeal, applying English law principles, has held that RDS owes an arguable duty of care to those impacted by oil spills from SPDC-operated pipeline. And as part of those proceedings, it has ordered RDS to disclose 4 categories of internal documents identified as being the most relevant to the determination of the duty contended for in that case. They are firstly copies of audit reports of SPDC compliance with the HSSE framework. They are secondly insurance letters from SPDC to RDS saying that it is complying with those requirements and how. Fourthly, reports by SPDC of the relevant spills. And fourthly, a health and safety plan and something called a hazard and effects register for Ogoni land. Now, they have been disclosed to the Dutch plaintiffs who have been relying on them to advance their case on parent company liability. We have asked the respondents for copies of those documents and they have refused. And you can see the correspondence relevant to that issue set out in bundle 2I from tabs 110 to 114 from 3522 onwards. I don't ask you to turn up now, but the fact of their existence and the status accorded to them by the Dutch courts underlines what we say is obvious. Key documents relevant to duty exist and have yet to be disclosed. And my fifth and final point on this heading is that the history of these proceedings underlines the importance of disclosure. It's only because fortuitously Miss Sedgwick came forth to give evidence that we took possession of the control framework document. We only obtained the HSSE framework during the course of the Court of Appeal hearing. Both, as I have said, are germane and, as Lord Justice Sales noted, affirmatory of our witnesses, but unexplained by the respondents. My lords, my lady, that's all that I wish to say about the approach of the Court of Appeal. Can I just make 4 bullet points by way of conclusion? My fifth category. Having said at the outset, this case was simple and capable of ready resolution, but of little more than Vedanta principles and the pleadings. Can I just say this? Firstly, we respectfully submit the majority fell into error by applying a restrictive test of the existence of duty incompatible with Vedanta. Secondly, the application of that test meant they assessed the relevance of the evidence through a skewed analytical prism. Thirdly, they compounded that error by failing to take into account the impact of disclosure and future witness evidence on the contested facts. And fourthly, simply on the basis of the pleadings, the claimants have an arguable case fit for trial on the question of duty. The position is a fortiori in light of the witness evidence and the additional documents secured. And for those reasons, the appellants submit that the appeal should be allowed.
Mr. Hermer, thank you very much. Lord Goldsmith.
My lords, my lady, as the court knows, our starting point and our fundamental proposition is that there is no error of law or principle in what the Court of Appeal did. And therefore, the exercise which Mr. Hermer is trying to persuade this court to undertake is not an appropriate exercise. One would have expected that at this level, before this court, one would see a limited appeal focusing on 1 or 2 propositions of law, instead of which what Mr. Hermer is actually inviting the court to do is to undertake a review of documents and material which were thoroughly looked at by the Court of Appeal and to some extent by Mr. Justice Fraser as well. And this is, we respectfully submit, what this court in Vedanta described as dressing up what is in reality a factual dispute, as it were, or involved a misdirection of law. That is in paragraph 13 of the Vedanta judgment of this court. And so, interestingly as well, it also is inviting this court to undertake the detailed factual analysis that Mr. Herman himself in Vedanta protested against. And that is at paragraph 47 of the Vedanta judgment, where it's recorded that Mr. Herman only engaged in discussion of the arguments that counsel for Vedanta wanted to engage in under protest on the basis explicitly that this was an inappropriate exercise for this court. And what this appeal seeks to do is to invite yet another bite at the cherry under the guise of the so-called four Vedanta routes. It's only the latest of the many iterations of the Appellants case. Indeed, the Appellants have ended up abandoning a number of their bare assertions, so that the case now bears no relation whatsoever to the pleadings against which service out of the jurisdiction was sought. And we do submit that the latest iteration of the claim is also completely speculative and bound to fail. But more importantly, or at least as importantly, all these allegations were considered in detail and comprehensively by the Court of Appeal. And they may be dressed up a little bit in different form by Mr. Herman and his colleagues, but they're precisely the same. I want to make this point, though I'll come back to it, so it's not lost sight of. Justice is available in Nigeria for bona fide claims based on operational spills. There's a straightforward statutory scheme. It imposes strict liability, which has been well used over the years. And in our submission, in all the circumstances, it's right that a wholly speculative case, based on the alleged failure of a parent company in this country to prevent, and I'll come to explain this, ongoing criminality on an industrial scale in Nigeria, which even the Nigerian government can't seem to control, should not proceed here. So I want to develop those points and obviously seek to respond to what Mr. Herman has said. But I start by recognizing that the amount of material that's been placed before this court is enormous. I mean, Mr. Herman has rattled through things, asked my lords to read documents after the hearing, given references. It is an enormous amount. And the reason that it's an enormous amount is precisely because he is trying to persuade your lordships, maybe, to undertake a review of the evidence and the factual basis of the case, even though that's been done before. Now, I will show my lords, my lady, that the Court of Appeal was focused on the right question and undertook the right analysis. I'm just going to make one point now, but I'll come back to it. Mr. Herman complained in the course of the submissions that he's just made to your lordships that the Supreme Court, the Court of Appeal focused on the control question. Well, I'll show the court that's entirely justifiable given what had been said in Vedanta, but it's also entirely justifiable because that was the case he brought to the Court of Appeal. The skeleton of my learned friend in the Court of Appeal used the word control, I'm told. 68 times. So the word control is used 68 times. So why he is now trying to distance himself from that part of his case, it's in his skeleton. Also, my lords can see this very easily by reading his skeleton before the Court of Appeal, and indeed seeing what's said by Lord Justice Simon in particular, who refers, I think it's paragraph 68, to the assertion made by Mr. Herman, that Shell had a high level of control. That was fundamental to his case. But I'll come back to that because I just seem to illustrate the point that I made. My Lords, we do say that that's an appropriate test. There's no evidence that RDS did in fact take over, intervene, control, supervise the relevant operations of SPDC in Nigeria. And I'll show my Lords, my Lady, that. On the contrary, and I do want to make this point because it differs from many other cases in the world you might envisage, what is SPDC? It is a substantial entity with over 3,000 employees, assets of billions of dollars, expertise in the matters in issue. It manages and is responsible for its operations and its mitigation of risk, including that of third-party interference in the infrastructure. And that, my Lords, will see in Mr. Okunbo's first statement, paragraphs 11 and 32. Now, my learned friend, Mr. Hermer, has already invited my Lords to read that, so I don't need to take the court to it now. I will want to take the court to some other evidence. As to further disclosure, both the first instance judge and the Court of Appeal considered the issue whether there would be further disclosure and rightly reached the view that there was nothing to suggest that anything would emerge on disclosure to improve the appellant's case. There's no doubt at all that both Mr. Justice Fraser and the Court of Appeal had that issue well in mind, and the appellants can't advance through a jurisdictional gateway so as to bring a Nigerian party before the court on what is a wholly Nigerian issue by speculating that something might turn up. And however elegantly and elaborately that's put, it remains Micawberism and nothing less. As to the documents on which Mr. Hermer relies, the Court of Appeal had those documents, looked carefully at those documents, as I will show my Lords, my Lady, and in fact evaluated the claim on that basis. That was their job. Having reached the view, the conclusion that Mr. Justice Fraser heard in certain respects, it was for them then to do the evaluation of the evidence. That's what they did, and they reached a clear conclusion they were entitled to. And that is an important distinction that we respectfully submit from the data. I'll come to that. But the fact is the volume of documents that actually the courts have in this case far exceed, and I understood Mr. Hermer actually to assert that, the documents which were available in Vedanta. I'll come to this, but let me just make one point at this stage. Mr. Hermer took, my Lords, to certain Shell documents, and I want to do that as well. But he didn't take your Lordships and your Lady to any document that actually showed what was the fault, what was the thing that was done or wasn't done by SPDC that would have made the difference. Bear in mind that the starting point for this is complaints about oil spills. Now, I have to show at the court that actually, though we don't deny that there can be operational spills, the real problem here is sabotage and illegality, which is causing pollution. So what we'll be looking for would be a control in relation to that aspect of the case. What is it that RDS should have done in London to stop people breaking into oil pipelines in Nigeria? That's the control that one would be looking for. But nothing of that sort is there, but there is one document he did not take, my Lords, my Lady, to, which is the most granular form of document which is produced centrally, and that is in relation to pipeline integrity. I will take, my Lords and my Lady, to that, and the court will see that that does not show that RDS is imposing from London standards, other than to say you need to have a plan to deal with this, but you must decide how to do it, and that's the fundamental point. I would also make these 2 points. It appears that the complaint in relation to the Court of Appeal is, at least in part, the level of detail at which they chose to conduct their evidential assessment. But they did review a very large quantity of material, including internal corporate documents, for which the appellants obtained specific disclosure at the Court of Appeal stage. And the lower courts were entitled to exercise their critical faculties. And I quote that from one of the cases in the bundle, Calland and FCA, the references at EF 5681 to 5682. The proposition is a clear one for the court. And the fact that the court below, the Court of Appeal, conducted a detailed level of assessment is not a criticism. It's a strength of the evaluation that the Court of Appeal reached. But essentially, the real problem is that the real complaint is that the Court of Appeal majority reached an evaluation which disappoints. It reached the conclusion that he wants. But that's not a ground for appeal. And I do note that the dissenting judgment, the Justice said, my Lord.
Sorry to interrupt, Lord Goldsmith. I just wanted to say your speech is breaking up a bit.
Yeah.
I don't know whether it's because you're looking at something other than your microphone, but in any event, you're not looking at the camera, but that doesn't matter. What really matters is hearing your voice in an unbroken way, which I'm not doing.
My Lord, I'm grateful. It's a shame that we had a problem with the technology here before, because I think it would have picked up better, but I will try to speak directly into the microphone. I'm conscious that there's a lot to do. I will do my best to get through it. I will do my best to keep clear in my speech. But if there's something I say that's not clear, I'm grateful to my Lord and I hope others will pick me up. So let me turn to the question whether the Court of Appeal were focused on the right question, as we submit they were, and conducted the right inquiry. So we say, in substance, the Court of Appeal applied the same legal test to the question of duty of care as was the test endorsed by my Lord Briggs in Vedanta, which is whether the parent company intervened in a relevant respect and to a sufficient degree in the management of the operations of its subsidiaries. And that's paragraph 44 of Vedanta. And given its significance, I would just invite the court just to glance at that. Is to be found at EF 4082. Where my Lord, in the third sentence, identified this as the critical question, whether Vedanta sufficiently intervened in the management of the mine owned by its subsidiary, KCM, to have incurred itself, rather than by vicarious liability, a common law duty of care to the claimants, or on the claimant's expert evidence, a fault-based liability under the Zambian environmental legislation. The level of intervention in the management of the mine requisite to give rise to a duty of care upon Vedanta is, as is agreed, a matter of Zambian law, but the question whether that level of intervention occurred in the present case is a pure question of fact. And that's a particularly important reason why what the learned friends are doing is simply inviting this court to take a different view on the facts. I will, given that, invite my lords to look at the same time in Vedanta at paragraph 62. And 61 and 62. 62 summarizes it, that it matters not whether this court will have reached the same or a different view from the judge, but whether there was material on which the judge could properly do so. And paragraph 61 I think that underlines that this court might have reached different conclusions from the Court of Appeal on the facts, but that wasn't the issue. Now, the appellant's case was based on control, and that's why the lion's share of the judgment of the Court of Appeal prizes an evaluation of the extensive materials said to demonstrate the requisite degree of control or intervention. And indeed, the case that Mr. Hermer presented in the Court of Appeal wasn't just control, but a high level of control. And indeed, that appeared to be the significance of Mr. Siegel's evidence, because he was brought to demonstrate that it was an unusually high level of control. Actually, interestingly, and this is in our printed case, I think in one of the footnotes, it's clear that although Mr. Siegel purported to contrast Shell's level of control with other companies, under examination in the deposition when he was giving evidence in the United States, he confessed that he hadn't actually studied the other companies. So how he could conceivably reach a comparison, I don't know. When it comes to the analysis of Lord Justice Simon, it's fair to say that because, I think it's probably fair to say both parties had encouraged the Court of Appeal to consider the case on the basis of the three-part test in Kapara. Lord Justice Simon talks a lot about proximity, but it's clear that what he and indeed both other judges were concerned with was level of control, level of intervention, the critical question that my Lord Woodbriggs identified. So in terms of whether the Court of Appeal adopted the wrong test, with respect, that's a complete non-starter. Then I turn to the evidence, because we do respectfully submit that there was here a concurrent findings on the evidence by Mr. Justice Fraser and the Court of Appeal. Now, I acknowledge, of course, that the Court of Appeal found 3 errors in the approach of Mr. Justice Fraser, and that's what justified them in substituting their own evaluation for his. But as they say, having corrected for those errors, they then reached, in fact, the same conclusion. So we have concurrent findings, which is a particular reason, of course, to be even more cautious for this court to reach a different conclusion. So what did the Court of Appeal find? They found, as did Mr. Justice Fraser, that in light of all the evidence, including particularly the documentary evidence, the appellants had not established an arguable case that RDS exercised a sufficient degree of control, or that RDS had direct responsibility for practices or alleged failures which are the subject of the claim. And that's why the Court of Appeal, at paragraph 124, concluded that the internal corporate documents, quotes, did not indicate the exercise of any degree of control or amount of control. I'm going to take, my lords, my lady, to those documents, because that conclusion is utterly justified. It's true that the evidence showed that there was some concern within the Shell Group about the security of SPDC's operation, but as the Court of Appeal said at paragraph 125, I quote, the concern was to ensure that there were proper controls and not to exercise control. That's a key distinction. And when one looks at some of the mandatory rules, and mandatory policies that Mr. Hermer has waxed so lyrically about, one sees that that's what they're doing. They are not saying this is what you must do. They're saying generally you need to deal with this, but it's for you to determine how to deal with it. And that is why, again, paragraph 126, the court concluded that even putting it at its highest, I'm quoting this at page 476, the exiguous evidence of centralised assistance to SPDC, contra distinction to all operating companies, doesn't come close to supporting the kind of proximity on the basis of which the court might find a duty of care to exist in favour of the claimants. And the Chancellor at page 198 saying, paragraph 198, I quote, the evidence doesn't indicate or even point towards either the exercise of any degree of control by RDS over the operations of SPDC or the assumption of responsibility. Rather, it suggests the reverse. Again, when the lordships and the ladies see the documents of those parts that Mr. Herman didn't take into we'll see why that is so. So perhaps I can just finish with this point before the short adjournment. The Court of Appeal conducted a de novo evidential assessment, concluded that the appellants fell well short of establishing an arguable duty of care, so there were therefore two separate and detailed evidential assessments reaching concurrent conclusions. If one looks at the time that was taken by the two courts below, 3 days in the Court of Appeal, a number of days before Mr. Justice Fraser, including additional hearings to deal with certain issues, such as additional fresh evidence. To do justice to that, again, in my respectful submission, in the very limited time for the day, just demonstrates why it would be appropriate to renew the evidential assessment already done by those two courts. My Lords, would that be a convenient moment, because I'm going to move to another topic?
Yes, I think, Lord Goldsmith, we will need to have a discussion between the technical people about your audio, because you were fading. I don't know if my colleagues had the same difficulty, but at the end of several sentences, your voice was fading away, and we were struggling to hear what you were saying. Right. So I wonder if your technical team could speak to Mr. Sheck over lunch, yes, to see if we can improve matters.
I'm hopeful that if we can revert to the system that we were using before, that might solve the problem. If not, I'll have to let us try. But we'll certainly talk to Mr. Sheck.
Yes. Okay.
And I do apologise for this.
Thank you very much. We'll take the short adjournment now and resume. If we return at 1 to discuss whether the problems are resolved or not. Thank you very much.